court is State versus Jones. Each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. Just please let me know. We're ready to proceed.
Thank you, Your Honor. May it please the court, I would like to reserve 3 minutes for rebuttal. Today, I want to focus on assignment of error number 1 in Mr. Jones's case before this court. However, if this court has any questions regarding assignment of error 2, I would be more than happy to answer those as well. This court remanded Phillip Jones's case back to the trial court for an evidentiary hearing with a specific inquiry, and that inquiry was to determine whether Jones's lawyers began their mitigation investigation early enough, and whether they allowed Dr. Siddle and Thomas Hurdy enough time to do a complete investigation into Mr. Jones's family life. As proven by the objective facts at that hearing, the answer to that inquiry is a resounding no. The objective facts before this court really haven't changed a lot, like even with the evidentiary hearing now in the record from when this court previously saw this case. At the evidentiary hearing, it was just proven that the mitigation investigation started after trial began. The mitigation specialist was not even retained until 3 days into voir dire. When he was retained, his name was spelled wrong on the order, so he couldn't actually even get started till about a week after that. So the trial phase was well underway and almost at closing arguments by the time he did anything on this case. And the only thing he did at that point was interview Mr. Jones once in jail. His investigation into Phillip Jones's life and his investigation and his interviewing with the family took place all after the trial phase in this case was already over. His first interview with family was on December 20th of 2007. Closing arguments in the trial phase were December 17th. So this mitigation investigation started very late. It definitely did not begin early enough. On top of that, there was just also not enough time spent. The totality of the amount of time that Mr. Hurdy spent on this investigation, speaking with and interviewing family members of Mr. Jones, was 10 hours. He had 3 meetings with them total. The first was an introductory meeting with Mr. Jones's mother and Mr. Jones's sister, Yolanda, and that, again, took place after the trial phase had already been concluded in this case. The second meeting that Mr. Jones had, or that Mr. Hurdy had with Mr. Jones's family, took place at Henrietta Jones's house. Henrietta was Mr. Jones's mother, who is now deceased. While the football game was on, he would pull family members out for 15 to 20 minutes and interview them, talk to them in the next room while a football game was playing, because it was December 26th. It was the day after Christmas. There's lots of football games on at that time. His last meeting with the family before the mitigation phase in this case took place was at Carrie O'Brien's office. That was a group meeting where the family all met in one big room for a couple of hours at Carrie O'Brien's office. They were asked questions and they were talked to. The maximum amount of time that meeting took was 2.5 to 3 hours meeting with this family. So again,
how do we deal with the fact that both defense counsel, who were fairly experienced, have testified that they did not feel that they needed additional time, and that had they thought that they needed additional time to prepare for the mitigation phase, that they would have asked for a continuance, and they felt confident that the trial court would have granted that continuance. How do we deal with that?
I have 2 answers for your question. The first one I would submit is actually Mr. Hicks at this time. This was his first capital trial, so he wasn't experienced in doing mitigation at all at this point in his career. The other thing that but the main answer to your question.
An aggravated murder case.
In an aggravated murder case with death specifications, yes.
But he was sitting second chair, so
No,
wasn't
that's
alone.
true, and,
He
no,
wasn't
he
alone.
wasn't alone.
Okay.
So the main answer to your question is, the objective facts are what should rule here, not trial counsel's subjective opinions. Trial counsel's opinions of what happened at the time, to be honest, are really not relevant to the inquiry. In looking at whether or not how they acted at the time and what they did at the time, you have to look at what a reasonable attorney in 2007 would have done. And according to all of the Supreme Court case law on this point, Wiggins, Williams, just to name a couple, Rompia, Porter, and the ABA guidelines, as well as hearing, which has been decided by the Ohio Supreme Court, that they just didn't. They did not meet those reasonable standards for investigation.
Well, we also have to factor in the fact that the trial court, and I believe, I understand that it was a different judge who heard the initial trial.
It was not. It was actually the same judge.
Was it the same judge?
Yeah.
Because my understanding was that the judge who wrote the denial of the motion for post-conviction relief was a different judge. That is correct. Okay. But that judge reviewed the transcript of the hearing and also agreed that it would not have made a difference.
So the inquiry that this court sent back to the trial court was whether or not Jones's lawyers began their mitigation investigation early enough and whether they had enough time. So again, I would have two answers to that. One, I don't think that the credibility determinations or the determinations as to prejudice that the trial court made are even relevant to the inquiry that this court sent back. But I also would submit that they're wrong. Mr. Jones had 7 different people, 6 whom testified in person, submit that there was sexual abuse in Mr. Jones's background. He also had 2 doctors, 2 psychologists, speak to the fact that, well, one spoke to the fact that Mr. Jones, he said that he believed to a reasonable degree of psychological certainty that Mr. Jones was a survivor of sexual abuse. And the other one said that Mr. Jones's background, his records in his life were replete with reasoning that would be very, that it's obvious that there was something going on in Mr. Jones's background and that it was very consistent with sexual abuse. The other thing I would mention is that the prejudice inquiry here should be left up to a jury. It only takes 1 juror in Ohio to make a difference. And as this court has previously stated, in light of the fact that it was Mr. Jones's rape of Miss Yates that resulted in the capital specification here, details about deviant sexual conduct that Mr. Jones endured or was exposed to as a youth would have been more relevant to his defense than his parents' divorce or his abnormal eye. And I mean, I would submit that this court has already decided the prejudice inquiry and that it sent this back really for more determination to make sure that trial counsel were actually deficient here, and they were. The other thing that I would mention is that Mr. O'Brien admitted on the stand that had he known about this, and he admitted he didn't, that he would have used it, or that he would have at least considered using it. And so I think that again backs up the prejudice analysis here in saying that had he actually done an entire investigation, he would have utilized this information, or at least at that point been able to make a strategic decision whether or not to use this information or not. But absent that knowledge, he wasn't able to make a strategic decision at the time.
But I guess that argument presumes that his diligence, and you have cast that in terms of having more time, that his diligence would have necessarily uncovered that information. And as I read the state's brief, I was struck by the fact that this, I can't recall his name, the individual who was assigned to counsel your client while he was incarcerated for investigation been given more time, then it would necessarily have come out, and I'm wondering whether that is so.
Well, again, and I know I always do this, but I have two answers to
That's
that.
okay, you can take them both.
And my first answer would be, this court's already answered that question to a degree. This court already said even if Phillip Jones didn't talk about this abuse, it's the family members that needed to be talked to about this abuse, because 6 different people have testified that they said, had they been asked, they would have told this information to trial counsel or trial counsel's mitigation specialist at the time of trial, despite Phillip Jones not talking about this information. The other thing I would say is that had they done a thorough review of the DRC records that were in front of them that they had from Phillip Jones's previous stay in prison, there was a point when Phillip Jones came forward and told someone that he had been abused by his father, and then he was ridiculed for it. And so it makes sense that he's not going to talk about it anymore if he's then ridiculed and it's spread around the pod. I would submit that.
Are you referring to the I'm trying to recall whether that's the incident that the state addressed in its brief, where your client later said that he just said that because he needed some help in making a phone call.
The state's allegation is that he was saying that because he wanted to move. It's not that my client actually said that. It's just that the state was saying that he was making it up. And my response to that would be, I don't know why you would make up something so incredibly personal that then gets spread around. And also, I would also submit that looking at that incident, and looking at all of the rest of his DRC records, brings me to kind of my next point, is had they reviewed those records, that you see they're replete with Phillip Jones's mental illness. And that's actually just a part and parcel of someone's mental illness. He's been diagnosed as
Counsel,
schizoaffective.
I was going to say, I was allowing you to answer Judge Moore's questions. You're in your rebuttal time.
Okay, thank you. I'll save the rest for rebuttal.
Now may it please the court, Richard Cassay, representing the state of Ohio in this case. A threshold issue is, I don't believe, this case was here before it was remanded for the hearing. I don't believe that this court found that Phillip Jones had been sexually abused, because all this court had at that point were affidavits from family members. The case was remanded for certain issues. We had a week-long hearing, and the trial court issued a very lengthy, detailed, and in-depth evaluation of all the possible issues that were contained in the remand from this court. Now, I want to make a couple points here. It's been stated that at the evidentiary hearing there were 6 or 7 family members who testified about sexual abuse. That's not true. There was only one family member, being Yolanda Jones, who testified that Phillip Jones was sexually abused. Other members talked about things tangential or completely unconnected with Phillip Jones. Now, as far as Yolanda Jones is concerned, 2 points about her. The trial court, after viewing her testimony, made the explicit finding that she was wholly unbelievable and her testimony was rehearsed. Second, there's an issue here about the investigation done by Thomas Hardy and insufficient time. time is not the issue. The issue is, was his investigation adequate under the circumstances, regardless of how much time he took? He said that he would have asked the family members about sexual abuse. Coffee Harmel, that's her last name, Coffee Harmel, and Yolanda Jones admitted at the evidentiary hearing before Judge Callahan that they had been asked, the family had been asked about sexual abuse. He did that. If they don't say, yes, there was, what more is anybody to do? The
When
attorney.
you say sexual abuse, you
Yes.
mean specifically of
In the family,
Jones.
in the family,
They
anything,
were asked generally.
anything,
Not just about the defendant.
not just about the offender. Any sexual abuse in the family, because that is prime evidence for mitigation. And the attorneys, O'Brien and Hicks, said, of course, if we had known about it, we would use it. Any attorney would do that. Dr. Bevan, ineffective for not using Dr. Bevan. It was, I think, pointed out by a question. While Jones was in prison, Dr. Bevan was one of his primary treating psychiatrists or psychologists. He was one of the experts over a 30-year period that failed to discover this alleged sexual abuse of Phillip Jones. 30 years, undiscovered. Now, at the evidentiary hearing before Judge Callahan, we have Dr. Fradkin. Who discovered it? How did he do that? Well, he used something called the FETI, F-E-T-I method, and I'm not able to describe it to you, but it is apparently, in Dr. Fradkin's opinion, a specialized tool that the psychiatrist can use to discover sexual abuse. That's what he used. Problem is, this tool wasn't even formulated until 2013. But we have the argument that trial counsel and/or Dr. Siddle and Thomas Hardy should have found this when it was discovered, according to Dr. Fradkin, with a tool invented years and years after the fact. The trial court addressed this, and she said, this FETI tool was invented in 2013, and that deserves no further comment. It does not deserve any further comment. ODRC records, it's true. In one point, in these voluminous records, Phillip Jones says his father sexually molested him. What was Mr. Jones trying to do? He was trying to get off the cell block. Replete throughout the ODRC records, which trial counsel is criticized for not using, is the picture of Phillip Jones as a fighter, a liar, and a manipulator. We can't just pick, or trial counsel could not have picked, cherry-picked this and that to make Mr. Jones look good. You put in the records are put in. That's the picture they did not want to paint, and they were not deficient for making that decision, that tactical and strategical decision. Facts are unchanged. Well, I think I've tried to answer that. The facts have changed because we've had the trial court conduct a hearing, a week-long hearing, view the witnesses, judge demeanor, and make findings in the trial court's discretion. What did the trial court say? A couple things. Failed to utilize, failed to discover, insufficient time, entirely baseless. That's what Judge Callahan said. All these claims. There was sufficient time. Hardy said he did have sufficient time. Hicks met with Jones 50 or 60 times in the jail. O'Brien met with him, talked to him. They met with the family. It doesn't matter if the Cleveland Browns football game was on the TV. Hardy testified in his experience that a relaxed atmosphere is in a family setting, a group setting, is better than one-on-one interviews. But he makes clear, if there's anything else you want to tell me, call me, here's my card. He did all that. Not a word about the sexual abuse, and they were asked. So what is this case about? The court had a hearing, it found the facts, it thoroughly analyzed this whole situation, and there's nothing to it. Either these claims of sexual abuse of Phillip Jones, they're either fabricated, or if true, and I don't know which, I have my personal opinion, but those are the two circumstances. There is no other, or no others. Fabricated, or if true, 30 years of professionals did not uncover it. Many places. Phillip Jones, he has a long background of being treated for various conditions.
Well, if they are true, it seems to me that they are so egregious in terms of the atmosphere in the home and the abuse that he underwent at the hands of just about everybody in the neighborhood, that had the jury known that, wouldn't you agree that it would be likely that at least someone would decide on a different verdict?
If it were reasonably discoverable, assuming it's true, and I'm not conceding that it is, it has to be reasonably discoverable in the exercise of professional representation. My point is, Your Honor, it was not, by over 30 years of professionals not discovering it, and discovered it allegedly by the expert with his tool that was not invented until 2013. Trial counsel in 2007 and 2008 are not omniscient. Whatever the public defender thinks they should have been, they're not. So, if it is true, then they were not deficient constitutionally for failing to discover it. Dr. Siddle didn't see it, their own expert, the defense expert, and numerous experts. So, if it's true, there was no deficient performance. And that's the test. Mental illness. The counsel mentioned that. There's no question that Phillip Jones was mentally ill. The dispute here, and the dispute at the hearing, the evidentiary hearing, was what label to put on Mr. Jones' mental illness. Dr. Siddle diagnosed him primarily with a mood disorder, depressive, antisocial personality, and there was one other second in the three, going down the tree. The experts, Mr. Jones' experts at the hearing, he's schizophrenic, schizoaffective, different labels. Dr. Siddle testified at the hearing before Judge Callahan. He acknowledged that. He knew that Mr. Jones had been given various diagnoses over the years, but he, Dr. Siddle, said I make my own diagnosis, even though it's, other people have done it before. This is what I came up with, and it's a label. The primary problem with Phillip Jones is mood and antisocial. Whatever else you want to call it, schizophrenia, schizoaffective. The point, Dr. Siddle said, I represented the main problem to the jury in mitigation. So is it now ineffective assistance because he didn't label it differently? The state says no, that's not the case. I think I've probably said it's impossible to go into everything that the trial court found, given the time constraints. But when the court, if the court has not yet studied the opinion from Judge Callahan, you will see that what I say is correct. Exhaustive detail. Every witness. She left no stone unturned. She fully complied with the remand from this court, and in her sound discretion found against Mr. Jones. So that decision should be affirmed. Thank you.
Thank you. Just quickly, some points. First of all, the members of the Jones family it also included two pastors who the trial court indeed found credible in their testimony. And they did testify about abuse that either Mr. Jones actually had inflicted upon him or that he was at least completely aware of at the time, and that also matters. The other thing I would like to note is I need to correct the record. Mr. Hurdy did not testify at the evidentiary hearing that he did or would ask about sex abuse. He actually specifically testified at the evidentiary hearing that he would not have asked about sex abuse and that he only asks open-ended questions when he's talking to the family. At most, Carrie O'Brien and Dr. Siddle at the evidentiary hearing made references to asking Phillip Jones himself, but no direct testimony at the entire evidentiary hearing existed that the family was questioned about sex abuse. In fact, Rhonda Jones, Pastors Hargrave and Fuller, Christy Coffey, and Shatori Jones all testified that they were not asked about sex abuse. And Yolanda Jones is the one remaining witness, and she really, in all honesty, couldn't remember, or she said that it was so quick she couldn't even answer. The state brought up records, and we're not just necessarily alleging that trial counsel were ineffective for failing to utilize the records. They were ineffective for failing to review the records. Dr. Siddle spent 4.75 hours reviewing the records in Phillip Jones's case. There's thousands of pages of records. Dr. Stinson testified at the evidentiary hearing that it took him 50 hours to go through these same records that it took Dr. Siddle 4.75 hours to review. So there clearly wasn't an extensive review of the records in Phillip Jones's case done prior to trial. And Mr. Hicks was also brought up. Mr. Hicks indeed testified at the evidentiary hearing that he met with Mr. Jones multiple times before trial, that he met with Yolanda Jones multiple times. However, Yolanda Jones also testified that none of those meetings were about mitigation, that she talked to him because she was asking for status updates of the trial or whatnot. And also, Mr. Hurdy listed his sources of mitigation information, and Mr. Hicks was not listed as a source of mitigation information. So if Mr. Hicks did learn anything that was related to mitigation, he kept it to himself. Lastly, the last thing I would like to hit is that...
Counsel, you're out of time.
Oh, sorry.
Yeah, that's
Okay, thank you.
Thank you very much. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides as well as released on our website. Thank you very much.